Okay, hello there. Thank you so much, everyone that's joined us today on this webinar. It's one of a kind in its nature. We're really grateful to be hosting Professor Bernard Hibbitts today, who's joining us straight from Pittsburgh, Pennsylvania. It's 6 p.m. right now for us in India. It's 7:30 in the morning for him out there. So thank you so much, sir, once again for joining us. We don't really need to say much in introduction for Professor Bernard, but just a little bit about his illustrious career for all the viewers today. Professor Bernard Hibbitts is a publisher and editor-in-chief of JURIST, which is a law student-powered legal news service that he created back in 1996. And from back then till now, he's won multiple awards and accolades in the light of the same, including a 2006 Webby Award. He's trained as a legal historian. His teaching and scholarship focuses on the history of lawyering in the West, which includes from the ancient times to the present day of law. And he's played multiple roles, and he studies about and researches about the multiple roles lawyers have played in American culture. He's especially interested in how shifting communication techniques and technologies, which is, for an example, speech, writing, print, and electronic media, have shaped and transformed legal practice, education, and thought. And in the light of the same, he's published various articles and blog posts talking about this entire issue at hand. Professor Bernard Hibbitts has attended law school at England's Oxford University as a Rhodes Scholar after studying and taking undergraduate and postgraduate degrees in Canada in political science and international relations. He later obtained additional law degrees at the Dalhousie Law School in his hometown of Halifax, Nova Scotia, and the University of Toronto, and has finally done an LLM from Harvard Law School. So that's quite a lot that we have to learn from you today, Professor. We're really happy that you've joined us once again. So let's get this conversation rolling. We have a few questions from our side that we'd like to present to you. And we are joined by a lot of students on our live stream. So if time permits at the end, we should take in a few questions from them as well. So without further ado, let's start. The first overarching question that we have for you is tracing your entire career over the two decades in academia, various aspects of law and technology. Could you share with us how have you seen the influx of technology transforming over the years, and how has it been positive in nature, and what are the shortcomings that have emanated from the entire process?
Well, thank you, Mustafa, and it's great to be here this evening to talk to everyone about so many different subjects. I'm sure in the course of the evening. Let me take the first question, Mustafa, and let's start there. So let's talk about technology. And let's think about, how technology has impacted law over the years. And actually, that's a great question for you to ask me, because in many respects, although technology has affected law, for centuries, for millennia, because writing is a technology, print is a technology. Obviously, the electronic media that you talked about are technologies. But if you focus on computers, what we generally think of today when we're talking about technology, interestingly enough, the impact of technology on law was really first felt in many respects right where I'm from, right at the University of Pittsburgh in the United States, because in the late 1950s and early 1960s, a young law professor by the name of John Horty began to experiment with putting Pennsylvania health law statutes on IBM punch cards to make them searchable. And he actually demonstrated this technology in 1960 at a meeting of the American Bar Association. And this was really quite remarkable because it was the beginning of electronic legal research, which of course has transformed law in so many ways. Now you've got Lexis and Westlaw and all the database companies basically playing off versions of his work. And he did that work so early that at that time it really was seen as something of a novelty, something that was almost amusing. And it wasn't until 15 years later, basically in the mid-70s, that the big database companies kind of caught up and started to do what they currently do. So that's had a major impact on law, obviously. It's changed the way we think about it. I'm not sure that all the effects have been positive. I mean, it's great to have so much law at your fingertips. It's great to be able to basically consult tens of thousands, hundreds of thousands of cases at a time. But to some extent, I also think that these techniques have reduced law, because lawyers start to get the impression that the answer is out there somewhere, and all we have to do is rustle around in the electronic cupboard and we'll find it. And they focus on keywords and other things like that. And again, this is useful when you're looking for very specific information, but in terms of crafting larger arguments, sometimes it gets in the way. So it's definitely changed how we work. It's changed what we do. It's changed what we are expected to do. Technology has. But the effects have not been altogether positive, although it's wonderful to have these tools at our disposal. It's even better nowadays that lawyers can do this themselves. When I went to law school, Mustafa, in the early 1980s, in order to run an electronic search at that time, you had to consult the librarians, who would go off and work with their special terminals that they would have for Lexis, for example, somewhere in the back of the library, and they would come out and they would give you these results. And that was fine, but of course it was very limited. Now that lawyers can do this on their own in the age of the internet, they can sit down in front of their own computers and run searches. I mean, that's been very empowering. That's allowed them to really do all kinds of things they couldn't do before. But again, sometimes it's a distraction. Sometimes it's not so good. Sometimes it's an excuse not to think about bigger issues. So we have to be very careful in how we use technology ourselves.
Yes. So just on that same note, as we look at how technology has impacted legal education and legal practice, a very interesting thing about your career is the entire aspect of legal journalism, and this gets me to JURIST as well. So could you tell us a little bit about how legal journalism as an aspect of this entire industry has changed over the years? Its importance in our lives has changed, and how JURIST for you has been able to bring that change. And what do you think for law students today, how legal journalism as this entire different domain in legal practice looks like?
So that's another big question, Mustafa. So legal journalism is nothing new. I mean, legal journalism has been undertaken for hundreds of years. You mentioned in your introduction that I'm a legal historian by training. And because of that, I spend most of my time, looking into the past, looking into the relatively distant past. But in this country, you can find legal journalists in the 18th century. You can see individuals in other jurisdictions, in the United Kingdom, for instance, engaging in legal journalism, lawyers engaging in legal journalism in the 18th and 19th centuries. It was not uncommon. Lawyers were attracted to journalism and have been attracted to journalism for a very long time. It's probably not surprising that they are, because lawyers are looking for platforms to speak on. I mean, that's true literally when they get up and talk, but they're still looking for metaphorical platforms to speak from, and they want to exercise influence. They're good communicators usually, and they're usually interested in the world, or at least some of them are interested in the world. And if you have that combination of interests or that combination of talents, I think you're drawn to journalism. So for instance, again, just to give you a local angle, because it actually lines up here, the founder of my university, the founder of the University of Pittsburgh back in the 1780s, was a man by the name of Hugh Henry Brackenridge. He was a lawyer. He obviously was interested in higher education because he set up this university, but he was also a newspaper publisher. He established a newspaper that became and is now, I suppose, the biggest daily newspaper in Pittsburgh, the Pittsburgh Post-Gazette. So he was a legal journalist. Some very significant individuals in the formative years of American jurisprudence were interested in journalism and tried to get their names in the papers, for instance. So, you may be familiar, and your audience may be familiar with the Federalist Papers, right, which is a great collection of writing basically on the United States Constitution. That was undertaken by Alexander Hamilton and James Madison and John Jay. These are critical American founders, if you want to put it that way. And what did they do? They didn't get up and say these things in court. They didn't get up and say the things they said in the legislature. They wrote letters to the paper. That's basically what they did. So they were acting as journalists to some extent. So legal journalism has a long and distinguished history on both sides of the Atlantic. And now, we are carrying that on JURIST. But, certainly it's true that between, the 18th century and the present day, legal journalism has had a certain trajectory and a certain popularity. Lots and lots of lawyers in the 19th century edited newspapers. They like to do that sort of thing. As law became more professionalized, in the course of the later 19th century, lawyers started to leave journalism. They started to give up that space. They left it to professional publishers and professional printers and professional journalists, which started to appear, because originally there were no professional journalists. And when they did that, they went off, the lawyers did, and sort of focused on their own concerns, but law remained important. It remained important for people to understand what the law was doing, how the law was changing. And so the journalism profession, as it grew up, began to take an interest, obviously, in what was happening in law. And, right through the 20th century, you've got journalists who are reporting on particular legal institutions. You have Supreme Court reporters, for instance, in the United States. I don't mean those people who publish the decisions. I mean people who are actually reporting on the decisions that are handed down by the courts and are presenting them in the newspapers for public edification. Actually, one of the members of JURIST's board of directors is a journalist who used to be the Supreme Court reporter for USA Today, which, as you may know, is one of the principal American national dailies, perhaps the only sort of American daily that isn't specifically attached to a location like the New York Times. So that is significant. But now I think we're in a position where lawyers themselves, and law students in particular, can and should and perhaps need to turn back and engage in journalism themselves. Because when you're a journalist, Mustafa, you're forced to look at the world. You're looking outside your own intellectual box, your own professional box, and you're engaging with the outside, and you're seeing what's happening out there. And one of the reasons why I have developed JURIST as I have over the past almost 25 years now is because I think that that's really important. Law students and lawyers need to be reconnected to the world in a variety of ways. They need to really know what's going on out there, as opposed to being sort of cloistered from it, separated from it, and only seeing it in very narrow segments which are related to what their clients are doing or what their clients want them to do. So I think this is an important part of their re-education. And I think they have something to contribute to the world. I mean, they could obviously share with the outside world what they themselves are learning, right? And I think that's very, very important for law students to be doing, because when you're in a professional school, as you and so many of our audience today are, you're getting all kinds of critical information about how the law works and what it does. And that information is not necessarily known to the public at large. They're not familiar with those things. Certainly, the public at large, apart from what they might read in the general press, is not that familiar with what's happening in law, changed on a day-to-day basis. But we have that kind of information. We have access to that kind of information. And I think it's incumbent upon somebody in the legal community, and it might as well be law students, it's incumbent upon somebody in the legal community to talk to people about what is happening in the law and why it's important, and explain it in some way. And if they do that, Mustafa, if they do that, not only are they helping the public, not only are they helping regular citizens, regular people understand what is happening in the law, they're helping themselves, because they're learning more about their world. They're learning more about the legal changes that are out there that are occurring all the time. they're getting experience in explaining those things. And you know as well as I do that if that you have to really know something well in order to explain it to somebody else. So they internalize all of this. And then, of course, they get experience in researching and writing about the law. That's great. That's a lot of what lawyers do, right? And so they're getting that kind of experience as they're doing this kind of work. So it's something that many people would describe as service learning, right? Service learning is the notion that, you are able to learn about things as you serve some community. Well, the law students on JURIST are serving the world by providing this information to them on an ongoing basis and helping them understand what is going on around them, what is going on in the public policy sphere, what is going on in law. I think that's good for the audience. It's good for the law students. I think it's just good educationally overall. So that's basically what we're trying to do. That's the idea behind JURIST. And yes, it is legal journalism, but I think it's time we went back to that idea and identified that as an important thing to do. I'll tell you a story, and then we can go to the next question. So I'd say 20 years ago, probably now, most of. I was having lunch with an old friend of mine who happened to be a dean of a certain law school. I will not name the law school. But we're having lunch and I'm explaining JURIST, and he turns to me and he's struck by what I'm talking about and how this could be interesting. And he said, well, law schools don't do news. And it wasn't so much an argument as it was a conclusion. That is simply not something we should do. That's not something we are intended to do, framed to do. It's not something we're supposed to do. And the conversation kind of stopped at that particular point because I couldn't move them beyond that. But I think the idea that I have is that, yes, we should do that. It's something we can do. And just because law schools, for instance, haven't done this in the past, or their students haven't done this in the past, doesn't mean they shouldn't do it going forward. And that's especially true, Mustafa, in circumstances and situations where fewer people, in some respects, are covering serious legal news, right? I mean, you and I can look at the internet or the newspapers, and we can see all kinds of stories about, crimes and celebrities and their interactions with the law and all that kind of stuff. But the amount of serious legal news that is out there is actually declining. I mean, the traditional journalists that used to do this job are not doing it as much because it doesn't sell in the way that other types of news sells. So again, why not send law schools and law students out to do this kind of thing? Why not re-engage law students with the community? And why not encourage law schools to give something back to the communities that they're in? It helps to recreate and reestablish some kind of dialogue, so we're not just all sitting in some kind of fortress separated from the communities around us. That's not going to do anybody any good. In fact, that's going to just make people mad and disappointed. But this is a way for law schools to reconnect with the public. It's a way for law students to reconnect with the public. And I'll say one last thing, Mustafa. It's a way for law students to rediscover the power of doing something as simple as telling a story. Because that's what news is. News is a story, right? And over the past 100 years at least, law students have moved away from that skill. Now, I don't know everything about legal education in India, but I can tell you that in North American law schools, there is a minimal emphasis on trial advocacy or any kind of presentational skill, oral argument or whatever that would allow and encourage students to tell stories. And even in the context where there is some emphasis on oral argument and litigation of some sort, students are trained to answer particular questions from the bench or to navigate general logical arguments, but they're not really trained to tell a story. And yet so much of law is rooted in story, right? You have to be able to tell stories at the end of the day. That was where law began in many respects, because you're telling a story to a jury or you're telling a story to a judge about what happened in a situation. We're not trained to do that. nowadays. But on Jurist, with our students writing legal news, they're telling a story. They're telling a story every time they write a news story. And I think that encourages them to be more comfortable with that kind of format. I think that's a good thing. I think that's an accessible format for people. And so I think it's a good skill. So there are all kinds of things together here, Mustafa, which I think encourage us and have encouraged me to encourage my students through Jurist to engage in legal journalism and to create something which is good for the public and which will teach them something at the same time.
Yeah, definitely. A lot of what you said was specific to America, specific to the law schools you've been around, the environment you've been around. But a lot of that can also be taken to various jurisdictions around the world. I mean, the deficiency which you said that present in the law schools in North America, similar things are present in India as well. So it's kind of a very similar, shortcomings that you see, similar positives that you see around this entire thing. So definitely, there's a lot that we can, absorb out of this entire conversation and understand how we can move forward as part of the legal community. And this brings me on to the next question on the very same line. As we were talking about technology before this as well, to what extent do you feel technology has sort of globalized the legal community to come together? This is different from the international law perspective. This is more of the how various jurisdictions around the world, their issues, how they look at the law, how that has been able to come together, and how globalization has kind of helped jurisdictions to work past what issues they've been facing in the 21st century because of the role of technology present. How do you think that has happened?
So you're right. The globalization is certainly a theme in law over the past, 30 years or so. I mean, certainly it existed beforehand to some extent. I mean, the United Nations wouldn't exist without a certain amount of, globalization after 1945. And I mean, globalization as a phenomenon impacting law can be seen in the 19th century and earlier. There's no question about that. People don't live in silos. They are influenced by other things going on in the world. But almost at every turn of technology, with every technological development, Mustafa, people have been drawn closer together with technology. And they've been able to literally bridge gaps and bridge distances. And I don't care whether we're talking about, laying the Atlantic cable for telegraph connection between the United States and England in the 19th century, or whether we're talking about the internet, which is just one big global cable, right? It does bring people closer together. And that creates the possibility of learning from each other and understanding each other and connecting with each other in the way that we're doing here, right? I mean, this is an example of globalization. Now, in most cases, that globalization is seen as potentially positive. In other words, people are looking outside their own jurisdictions and they're looking at how other people do other things. And they're thinking, well, maybe that's advantageous. Maybe we could learn something from this. Sometimes globalization results in the other kind of response, where people become resistant and they find that the world is intruding upon them and they want to push it away. I can't help but think of the recent experience of the U.S. Supreme Court, Mustafa, and I'm not a Supreme Court scholar per se, but I do know that in this country, the United States Supreme Court has been very resistant to applying international legal standards in a variety of ways. It has resisted international law, almost suggesting in some respects that it's somehow noxious to American tradition, which is foolish in a variety of ways, because American tradition was not invented in the air. It came from other places. It was influenced by other ideas, primarily European and English. So that's a ridiculous stance. But it's done to some extent out of arrogance. It's done to some extent out of fear. And it stands in contradistinction to the attitudes of other jurisdictions towards international precedent and international example. Again, you don't have to take anything and everything that's out there. You can pick and choose. You can do what you like, or you can't ignore it. But it's interesting to me, speaking as a Canadian, that Canada has always been a jurisdiction that's been quite open to other examples and international and foreign influences. And in this context for us, technologically driven globalization has been empowering because it enables us to pull precedents from all kinds of directions, from Australia, from India, from the United Kingdom, as we always have, a variety of sources. But Canada is that kind of culture because Canada is sort of at a crossroads, right? We've always been between, for instance, the United States and the United Kingdom. And so we're used to going in both directions and being open to influences and examples from other places. But the Americans are in a different circumstance. And they don't necessarily react positively to all of this. And there's a power calculation there as well, of course. So globalization itself can play in different directions, but globalization as a larger enterprise can open up all kinds of possibilities, and even though we're now in this age of globalization, and even though in very recent years there has been an attempt in various countries to step away from globalization, I think we're on the cusp of even greater globalization. I think technology and to some extent circumstances, such as the coronavirus, have pushed us or pulled us in this kind of direction. The fact that you and I are having this discussion today in front of this audience, this is a testament to the power of technology and globalization in an age of COVID, when people are to some extent not able to connect physically. They're forced onto a virtual playing field. They're forced to be online. And of course, if they're online, they want to connect. And so, it's great that they can do that. It's great that I can speak to you at your law school in India. It's great that we can have this conversation as easily, Mustafa, as I can have a conversation with one of my own students who's online a couple of city blocks away from me. So globalization can pull us together. And what's even more remarkable about this form of globalization, what we're doing this morning, is that for the first time, really, we're able to bridge distance while seeing each other face to face, right? I mean, yes, theoretically, we could have done something like this, Mustafa, a year ago, and we could have organized ourselves to have a video link between, Pittsburgh and India, and it would have been fine, and it would have been fun, and that's great. But it wasn't a common thing to do. Now it's a common thing to do. And whether it's me talking to you and your audience, and we are face to face in some context, or whether it's me talking to JURIST staff, which is now, all over the world, it changes the equation to be able to deal with and work with people in a face-to-face environment. So in that context, the circumstances that we're in, I mean, the awfulness of COVID and all of that is not just something that has wreaked havoc with our society. It is something that has drawn everybody onto the same virtual playing field. It has allowed them to literally look each other in the eye and connect. And when that is done, I think that has a tremendous capacity for opening people up to new ideas, new voices, new ways of looking at things. I mean, again, maybe this is technological optimism, but I do think that it helps us appreciate each other's humanity over huge distances. I think it will change the way we feel about each other globally going forward, because when we put people together in this way and at that level, whether we're lawyers or whether we're citizens or whether we're anybody else, I think great things can happen because we can relate to each other in new ways. So this is very, very powerful. So the type of globalization that is going on, Mustafa, in this particular technological context, I think has a tremendous potential. And it's changing institutions, it's changing how you work, it's changing how we work, it's changing how we all collectively work together. And I don't think that we really realize at this juncture how powerful and how remarkable it's going to be even after we go back to quote unquote normal, because I don't believe we're going to ever go back to normal in the sense of the way it was. I think the technology is here. I think we will still take great advantage of it. I think it will still make a difference. And I'm excited to see where that leads the legal community. I'm very excited to see where that leads JURIST it will certainly, I think, be transformative for us, and I hope it's transformative for the legal community as a whole.
Definitely. And on the same tangent, we want to also hear from you about the courtroom practice side. How have you seen a tactical shift with now that we have video broadcasting and we have this kind of a technology being used now, because, and especially because of the recent pandemic, it's been accelerated more. How do you feel? I mean, because you have experienced how the law works in various jurisdictions around the world, and you've seen how developing jurisdictions, India as one example as well. How do you feel things have changed for them? And what do you think could be the implications which come out of the same in the coming future?
So technology, Mustafa, always impacts courtroom practice, right? And again, this is not an invention or a development which is unique to the 20th century or the 21st century. And you'll have to forgive me because as an historian, I always look back, right? I always go back. So, let's look at the 19th century. So in the 19th century, technology changed courtroom lawyering in one way that we usually don't think about. The development of inexpensive publishing, industrially generated publishing, in the 19th century helped to make it easier to produce books at a rapid rate, helped to put books in the hands of all kinds of people, made books cheaper to acquire for lawyers and other groups. And as that happened, lawyers and judges placed more reliance on books as sources of authority as opposed to simply legal argument in court. And so in the United States and other jurisdictions, during that time period, you see more reliance on written briefs and you see less reliance on oral argument. So for instance, in the early 19th century or in the early decades of the early 19th century, somebody like Daniel Webster, sort of the greatest American courtroom orator of the day, could literally go on for days in front of the Supreme Court of the United States, and they would let him go and it would all be fine. But by the time you get to the middle of the century, under the influence of written briefs and more available legal treatises, the court is saying, no, just write it down and file it. We're busy. We don't have all this time to listen to you. So in that context, that kind of technology started to close down the traditional form of oral legal rhetoric. And we're still dealing with that today, because if you go into the Supreme Court of the United States, you get a very limited time to argue, right? Daniel Webster would be out of business. So technology has always impacted legal practice and has always impacted courtroom argument. Now, in terms of electronic technologies, what impact have they had? Well, most obviously, they have allowed courts, should they desire to do so, to broadcast and stream their proceedings. Again, this goes back a long way. In the US, again, I can't speak to England or India, but in the United States, courtroom proceedings were broadcast as early as the 1920s on radio. Some members of your audience might be familiar with something called the Scopes Monkey Trial, which was a famous or infamous legal proceeding that revolved around the public teaching of the doctrine of evolution. That trial was broadcast on radio in the 1920s. It was a sensation. Everybody tuned in. Partly because of that experiment and partly because of the notoriety of that trial, the bar at the time, the American bar, tried to make sure that trial broadcasting did not go forward. They thought it was unseemly. They thought it was beneath the dignity of the court. And so you had to wait until the 1980s, basically, for a significant push against that, again, as the society becomes more oriented towards television and more used to that kind of presentation. So then in the 80s and 90s, you've got, in the United States, you've got court TV, you've got, again, courts opening themselves up. But then you run into something like the O.J. Simpson trial, in the United States in the 1990s. And people say, well, no, this is too much. I mean, we shouldn't be broadcasting this stuff. And again, courts, please don't do this. And courts kind of retreated. Now there's again a movement in the other direction, and there's greater pressure and greater public pressure to have courts do this kind of thing and make their proceedings available this way, because it's all about accessibility, right? It's all about making law open and available, because a court as you and your audience know, is a public space. So this is one way of fulfilling the court's mission to conduct justice in public, which it should be doing. It should not be conducting justice in private. But not everybody is convinced of the value of this. So let's look at the Supreme Court of the United States, for instance. The Supreme Court of the United States has yes, they've made some progress, because nowadays, for instance, you can listen to the oral arguments of the court online. They are broadcasting in that sense. They've just come to that in the last couple of years. Although they've recorded proceedings for their own purposes going back into the 1950s. But only recently have they actually broadcast. But they still resist doing it visually. They still resist any kind of visual exposure. And that's really interesting, because there's no television broadcast of the U.S. Supreme Court. And if you actually want to see the court, if you're not a lawyer involved in a case, yes, you can go to Washington, D.C., and you can, take one of the tours, and you'll be, ushered into the Supreme Courtroom, where you can sit there for maybe, 10 minutes, 15 minutes if you're lucky, and hear parts of an argument, and then you're ushered out again. I mean, it's not a visible process. The Supreme Court of the United States is one of the most invisible courts in the Western world. Compare it and contrast it, for instance, with the UK Supreme Court, or again, the Canadian Supreme Court, and you'll see something different. So in the context of the United Kingdom, their High Court has been broadcasting essentially since the early 2000s. They're less concerned about the so-called problems of broadcasting court proceedings to the general public. The Canadian Supreme Court has been broadcasting court proceedings on and off since the 1980s. And that's really quite remarkable. But it's interesting, how this works, because it seems that the courts that have the most power in their countries are the most resistant to broadcasting of their presentations, or at least visual broadcasting of their proceedings. So the Canadian Supreme Court, probably, the most limited in power traditionally. It's now getting more powerful with the Charter of Rights, but it's traditionally been less powerful. It was able to broadcast early and easily. The UK court, the UK Supreme Court was created out of something else originally. And it has power, but again, it exists in a system of legislative supremacy, so it doesn't have huge power. And they were okay with broadcasting. But the American Supreme Court, which is really remarkable, which exists in a country dedicated to judicial supremacy in many respects, is the most powerful, and yet it is the most resistant. So broadcasting of proceedings can be challenging politically for a court, because it interrupts and undermines the mystique of the court, the majesty of the court to some extent. Because when you look in the screen, Mustafa, and you look at the judges, you realize they're human. And if they're human, they can make mistakes. If you just read the decisions, or even if you just hear the disembodied voice of the judges on the court, that has more power. So I think the U.S. Supreme Court resists the idea of courtroom broadcasting because they do not want their power challenged. And again, just look at the building, right? I mean, the U.S. Supreme Court building just screams power at you in so many ways, with the columns and the architecture and the scale and everything. There's no equivalent to any of this anywhere else. So that's interesting. But I think the tide is turning, and I think eventually, they will end up going online, and they will end up streaming all their proceedings visually as well as in audio form, and that's probably good. And maybe the sooner that happens, the better. Even though at least one former United States Supreme Court justice, I think it was Justice Souter, some years ago, maybe a couple of decades ago now, said that cameras would be allowed into the U.S. Supreme Court over his dead body. I think when the cameras ultimately come in, he may no longer be with us, but nonetheless, I think it is coming in some form, especially as the expectations of the community change. But there's another side to this, and I'll mention this briefly before we go on. And that is that, of course, lawyers have to think about how they will take advantage of, or how they will work within the parameters of a court which is broadcasting its proceedings, or how they will behave when they are broadcasting themselves to it. So, of course, in this kind of environment that we're in now, everybody is arguing virtually. In so many different situations, courts are closed, right? So lawyers are arguing virtually themselves. And so that makes the lawyers more used to the idea of broadcast and sort of exposure of court proceedings. Lawyers will start, they haven't already started, they'll start to think pretty soon about how they should argue differently in an environment where they are streaming themselves to the court and where the court is only seeing them on the screen as opposed to in person. And I think this is going to change legal rhetoric in a variety of ways. I think this is going to change the way lawyers argue, because they're going to be reaching for different sources of authority, and they're going to be interacting with the court in a different kind of way, using different tools than they would if they were just appearing before the court visually, or I'm sorry, physically, or providing to the court your traditional written brief. So I think every technology changes the way, not just that judges appear to the public, but it changes, every technology changes the way that lawyers present themselves to the court. And all of this may happen at different rates as you move from jurisdiction to jurisdiction, but I think eventually you will see major changes coming from new technologies that allow lawyers to do new things in presenting their arguments to judges.
Yes, Professor. And as much as we see technology being an enabling tool, bringing people together, a flip side to it is that also technology sometimes becomes a little exclusive in nature. You go to rural parts of a country, or you go to less developed portions, less developed jurisdictions, where there's not much access to technology. So how do you think how do you think lawyers or legal practice in such environments can work post the pandemic? How can they adapt themselves? What do you think should be done in that regard?
That's a difficult question, Mustafa. I mean, you're right that technology is a double-edged sword, right? And it's fine for people who have it, and it's not fine for people who don't. I think that developing access, promoting access to technology is critical. Certainly, we are more conscious of that now in the United States in the context of the pandemic. People are much more aware of segments of the population that do not have Wi-Fi, do not even have computers that they or their children can use for educational purposes. And similarly, there are areas of all countries which are kind of internet deserts in a variety of ways, where connectivity is very limited, or where the population is poor, and even the lawyers do not have decent access to technology. So inevitably, some of us may be doing things the old-fashioned way for some time. The problem is that in that kind of environment, there is a danger that lawyers doing things the old-fashioned way will be shut down or shut out to some extent, and the people they represent or the people they argue for will be to some extent shut down or shut out. And that's a danger. That's a danger. So let me give you a little bit of an example here. In the United States, and this is not just a technology point, this is a general social point, but in the United States, over the past century or so, there has been a significant urbanization of the legal community. More and more lawyers are concentrated in cities. The big firms that have now spread globally are all concentrated in cities. They are not concentrated in rural areas. They are not present in rural areas. But all the people haven't moved away from rural areas. So you end up with large parts of the United States, for instance, where lawyers are relatively thin on the ground, they're relatively rare, and where people have trouble finding legal representation. Obtaining legal aid, for instance, is very, very difficult in a variety of places in the United States if you don't have any money, and rural areas can be very poor. And that creates a bigger problem too, because if lawyers are not present in certain areas of a country, those places may not just lack legal services, and they may not just lack connection to the legal world. They may lack connection to the political world. They may lack all kinds of representation in a variety of different contexts, and they may be disempowered because there are very few lawyers to represent their interests at all. There are very few lawyers to stand for them in court. There are very few lawyers who might represent them in the legislature. and they become disempowered. And if they become disempowered, what happens? Well, their dissatisfaction grows, right? Their discontent grows, and they may be inclined to strike out and do rather remarkable things because they don't like the way the system is going. This has happened in the United States in the past 4 years, right? So if you have a part of a population that is disconnected technologically, or economically, or politically, or legally from the rest of the community, bad things can happen. So maintaining access is very, very important. Expanding technology to include everybody is very, very important. Giving people the knowledge and the tools to use the technology is important. And I think lawyers cannot take technology for granted, and they have to look behind them. At least the National Bar Associations and other groups have to look behind them and think about the people who are not as privileged as the lawyers in the big firms who can stand there and use their technology to make remote arguments to the Supreme Court or whatever. What about, some lawyer somewhere else who just has no opportunity to do that? How is he going to function? How do courts react to this kind of situation? I mean, it's very important that we don't leave people behind that way. So technology can include. That's great, and I've talked about that. But you're absolutely right to say that it can also exclude, and that's dangerous, and we want to change it. We used to talk a lot in the last century or so about the development of universal literacy, right? And because, of course, the ability to read and write is to some extent, a technology. And it was very important for social success across the world. In the past 100+ years, for everybody to be able to read and write, for everybody to become literate. And that is not the case everywhere still, but at least this was seen as a universal value. Now, to some extent, we need to do something else. We need to make sure that everybody becomes sort of, to coin a phrase or to coin a word, neterate. In other words, that they are all connected in some way, that they are all networked in some way, and they have this capacity to connect with each other and work with each other. And if they don't have that, that should be seen as a bad thing, and we should be fixing it at the policy level. And lawyers can contribute to making sure that that happens. They can contribute to making sure that that happens by making sure that all lawyers have that kind of ability and can interact with courts. They can help to ensure that that happens by making sure that citizens in general have that kind of connectivity and access, because that's good for countries, it's good for democracies, it's good for people and the public interest generally. So I think that we have to be proactive in making sure that people are connected. And then once people are connected, it is easier to provide them with information and other things, which again can educate them about what their options and opportunities might be. But if you don't have the technological access, none of what we are doing here and none of what we are doing on JURIST is going to make any difference, because the people who are cut out will not be able to see us or hear us at all, and they won't be able to be part of this conversation. We want to draw everybody into the conversation. We want to make sure that technology is used to include everybody in this large virtual space that we're all creating together.
Okay, so we do have a few questions from our audience that's watching us live right now, and there are questions from around the world actually. So I'd like to put them out to you, which is on the note of what conversation we've been having, obviously. So we have a question from Eleanor Ben, who's from UK. And she says that, and she is going back to the aspect of legal journalism and technology. And she says that most of the top journalists have been lawyers by trade or education. But she says that if one wants to become a journalist, if one wants to become a legal journalist, why is it a necessity to be studying in the legal field itself? Can't you just be studying in the broadcasting field and just become a legal journalist? Why is this an important and emphasis towards being a legal journalist, studying the law and then presenting it to the people?
That's a great question. And I think traditionally it was perhaps more possible to cover the law, report on the law without having a law background. Certainly there are lots of journalists in the United States and elsewhere who do this without a law degree or without legal training. But I think the legal training helps because law is so complex and it's so nuanced, and it's becoming more complex and nuanced all the time. And if you just have a passing understanding of legal doctrine or legal institutions or legal procedures, there is a greater likelihood that you will make a mistake in your interpretation or your presentation. And in that context, you may do a disservice to your readers, to the people who you are trying to reach and inform. And increasingly, I think journalists, legal journalists, are recognizing this themselves. And yes, as you note, Eleanor, I think it's, yes, definitely true that a good number of leading journalists in both the UK and the US, not only in the print medium, but also on television and in other contexts, are lawyers because they have command, easy command of the ideas, the doctrines, the concepts that they need to work with to report on what is happening in the world. You scratch a television presenter, down here, and you may find a lawyer underneath. It's not uncommon. What's even more interesting is that in recent years, I actually have a number of friends and colleagues here in the United States who are journalists who have actually made the decision to go to law school to enhance their ability to report on legal developments. Some of them have not taken full 3-year programs in American law schools. Some of them have taken truncated, single-year programs, Masters of Studies in Law or other degrees like that, which give them some modicum of legal training, but they found it useful. They forced themselves out of their own career paths to do this. So they've made an investment of time and money in doing this. At the same time, individuals who are in law schools currently find themselves, at least in my experience, find themselves drawn to journalism careers because those, again, are public facing. They're highly engaged. Those individuals are highly engaged in working with public issues. Some lawyers like this more than they might like arguing in court or doing transactional work. And so you see more students going into legal journalism, more law students going into legal journalism now than you would have seen 20 years ago or so. This has certainly been the case again with a variety of individuals who have gone through JURIST in the last couple of decades. We've got our students working at a variety of legal news operations, both domestically, in Bloomberg, for instance, and in other locations and with other media abroad. And I think that's great, but they are taking advantage of their legal training. And I think they realize that in order to really be successful at reporting legal news, they need to have that kind of background to be accurate, to be nuanced, to really understand the importance of what is going on. The law has become very complex and difficult to work with in a variety of ways. And so to some extent, we need experts. And the benefit of jurist is that law students get used to doing this when they're still in law school. And I think that can be very, very helpful for them, not just if they are going into traditional legal careers, but specifically if they want to go into legal journalism. That's not why we're doing this, but I think it's a predictable side effect, and I'm glad it's encouraged people to go in that kind of direction. So journalists need to be as fully equipped as possible to do the work they do. If you're going to do legal journalism, then some degree of legal training, some form of legal training is certainly desirable, and I think you're seeing more people going after that kind of training for that purpose.
Okay, moving to a little bit of the courtroom practice aspect. Two of our viewers have actually asked a question on a similar note. That do you think that it is a time that now courtrooms shift their practices virtually, and tomorrow, once the pandemic lifts up and things go back to normal, physical appearances might become a thing once again? Should the courts then not go back to the old conventional methods, and should they adopt to this new normal? Would this be more beneficial, or would the traditional ways of lawyering be something which would be more preferred over than what's happening right now?
So that's a great question too. So should courts and lawyers go back to the methods they used before? No. I think the genie is out of the bottle, the cat is out of the bag. I mean, I can multiply these awful metaphors, but I think it's too late for that because there are advantages. There are advantages to courts. There are advantages to litigants. There are advantages to lawyers. There are advantages to the public. Does that mean that we're only going to have virtual courts from now on? Does it mean that we does it mean that we will only have virtual proceedings? No, it doesn't mean that at all. There will be some measure of physicality, reintroduced to courts, and there'll probably be some kind of middle ground. But even before the pandemic, even before COVID, courts and lawyers were moving in this direction. All this has done is accelerated things, right? And so in this environment, it's almost as if we're engaged in one big test, right? We're going to see under extraordinary conditions whether any of this works. And what we're finding is that, hey, some of it does. Some of it is, some of it's inconvenient for some people, but some of it is very helpful for certain people. And maybe some of it is helpful for all people in some ways. So the new normal is going to be different. It is not going to be what we saw before. It is going to have a high degree of virtuality to it. It's going to have a high degree of technological support underneath it. And the physical presence of the lawyer in the courtroom will supplement that, but the balance is going to shift. So, up to this point, maybe we had, sort of 90% physicality and 10% virtuality when we're talking about lawyers in courtrooms. Now we've gone to 100% virtuality, right? When we go back, yes, we're going to have physical presence, lawyers will be there, but there'll be a lot more work done in a virtual space. And that's going to be even more true as the generation that is going through all this now as young people. Staff, I'm talking to you, I'm talking to your colleagues who are out there in the audience. You're used to this. You're going to see this as normal. You're going to see this as something that you can easily do because you're going to figure this out. You've already figured this out. We wouldn't be having this conversation if you hadn't. So when you get those people into legal practice, they're going to do what they're used to, and that's fine. So no, we're not going to go way back to the way things were before. Things were already changing. This has just accelerated everything. It's the same thing with JURIST, right? Because JURIST as an enterprise, as an exercise, existed in sort of pre-pandemic, pre-global form. We had, plans and aspirations to do, things at an expanded global scale at some point if the technology, developed to make that happen. But then when, COVID came along, the world went virtual, everybody was on our playing field, and suddenly we could make all these connections with all these students working from remote locations who could help us do what we do. And so JURIST kind of went virtual, we were already virtual, we went global, overnight. In a very, very limited period of time because circumstances allowed that to happen. When things change or when they go back to quote unquote normal, are we just going to fold up and go back to being, a virtual operation primarily staffed by law students in Pittsburgh, Pennsylvania? No, we're not going to do that. I mean, we're going to use the opportunities provided by the technology to continue to reach out and to include everybody in what we do. So no, we're not going to go back to where we were. It may not be exactly the same, obviously, when we go back as it is now. But I think the balance will change, and increasingly, I think courts and lawyers will be more and more virtual, more and more technologically based and technologically driven, and that may not be a bad thing.
Okay, this should be one of our final questions for today's discussion. Again, touching upon that legal historian side of yours, we would like to hear a little bit about how you've seen legal education changing over the years. How have you seen across various jurisdictions, the various countries you've studied in, you've seen how law is looked at, interpreted. How do you think that has changed over the years? How has that reflected in our justice system? How we can perceive justice, perceive things around in the legal industry, and how is that changing over the years now, especially since the pandemic has also come in, so that being another factor.
Wow, so that's a big question, Mustafa. So when it comes to the impact of technology on legal education, I mean, yes, technology has had an impact on legal education, but legal education, just like legal practice, has been resistant to technological change over time. I mean, lawyers to some extent have been resistant to technological change over time. I mean, people have said on many occasions that the law is a conservative profession. It likes to do things the old-fashioned way. Sometimes the old-fashioned way means the way it was done in the 16th century. But eventually we catch up, but it generally takes a while. Legal practitioners are usually more on the forefront of technological change, or at least some of them are, than law schools or legal educators or law professors generally. We tend to be somewhat slow on the academic side, and there are a variety of reasons for that, and I won't go into them here. But the way we teach, for instance, is at least in a classroom sense, when we're teaching in a classroom context, has not been greatly impacted by technology. If you look at how law professors operated in any time from the 1980s to the 2020s in the classroom, it wasn't that different from the way we had operated in the beginning of the 20th century. I mean, yes, some people would use PowerPoint slides. That would be about as far as we got. But other professors in other disciplines were more sophisticated in the things they were doing and the techniques they were using. Now that we're in this virtual environment, more law professors are experimenting with more types of technology, and I think that is probably going to be helpful going forward. It will probably change the way in which we teach. It will change the way in which we think about teaching, because we'll be able to use different tools in different settings than we would normally use in a regular physical classroom environment. So I think more change is coming, but the institutions of legal education, the institutions of legal academia are still very much oriented towards the past. So let's talk about an institution which I'm very familiar with for a number of reasons. Let's talk about the institution of the law review, right? The law review, especially in the United States, Mustafa, although you have obviously law reviews now popping up at more law schools in England and elsewhere, even in India. The law review as a form has been around since the late 19th century. That's fine. Law reviews really allowed faculty to take advantage of students, maybe I mean that literally, take advantage of students who could help the law professors, publish and to some extent write their articles. But law reviews were a product of their time, and they actually took advantage of this cheap print technology that came in the context of the later 19th century that I talked about before. Now, law reviews have gone online these days, and that's nice, but that doesn't change anything. I mean, that's been a very conservative use of technology. Because you go online and you look at an online law review, it's basically set up the same way as a print law review was. It just looks like the thing was dumped online. I don't think that kind of transition gets us very far. I think that in order for legal educators or anybody within legal academia, whether you're a professor, a student, or anybody else, I think in order to really take advantage of technology, you should be thinking about not just how to do the old thing in a new context. You should be thinking about how to do the old thing in a new way. You should be thinking about how technology enables you to change what you're doing. So in the context of law reviews, if I were thinking about law reviews, I would be saying, well, yes, we can publish articles online now. That's great. But, maybe that means we should change because we have different technological forms available to us. Maybe it means we should change how we structure the article. What makes up the article? Maybe we could, integrate multimedia. Maybe we could, import tools and applications into a law review setting. Maybe we can do all kinds of things that would make that medium different now to suit the technology that's available to us. And not just be a mirror of the old-fashioned way of doing things when you sent the law review to the printer and you were happy with the product. So I think we should not be conservative in how we use technology in the legal education field, in the legal academy, that way. Same thing with JURIST. And I guess maybe I'll kind of come back to this at the very end here of this question. And that is that, JURIST has no precedent in print. In fact, you couldn't do JURIST in print, either that or the poor students who are working on JURIST would be laboring away at producing some kind of printed newspaper, which would then be shipped at enormous cost, all over the world to readers, and we couldn't do it, right? It would be impossible. Maybe that's why law schools don't do news, right? Because, under the old regime, the old technology, it was not possible to do this kind of thing. But the technology that came along in legal education for us enabled me as a law professor, enabled my students as law students to do things differently and to do new things. And that's why JURIST has succeeded. It's because it's something new, it's something different, it's something that is not something that could have existed before. So what you want to do in the long run, if you're being innovative and if you're making proper use of new technology, I think is to create something different, something that is native to the new environment, something that makes sense in the context of the new technology, because no technology ever just recreates the old thing. You know, it's interesting because, you know, with technological history, that's how things happen, right? I mean, originally, you know, motor vehicles were thought of as horseless carriages. Well, of course, you know, ultimately we got away from that notion, and cars are now very, very different from what carriages were, right? But again, technology allows us to do new things. So has legal education realized the promise of technology? Has it recreated itself to do things that are more possible or perhaps only possible in this new technological environment? No, we haven't got there yet. We're still basically imitating old forms. We're imitating the law review by putting it online. We're imitating traditional teaching by just putting, you know, lecturers online talking to people, which is basically the classroom just virtualized. But we can do more than that, right? It will take us a while to figure out what that more is, but we need to start experimenting. And on JURIST, that's what we're doing. In other environments, other people will be experimenting, other professors will be experimenting, doing new things. And so I think that ultimately legal education broadly in 50 years is going to look very different than what it looks like now. But usually the change takes place very slowly. Perhaps this problem that we all face around the world right now is going to do something unusual by forcing us to entertain and embrace change much faster, much more quickly than we would otherwise, and maybe that will have unexpected benefits for everyone.
I think with this, we can just get to the last one question before we wrap this up. Taking a page out of your illustrious academic career, students watching us today would like if you could share with us a little piece of advice on how you went about with studying the law, looking at the law, interpreting it, bagging so many degrees over the way. So, what would you like to share with us as we move forward in the same journey as yours? What could we learn from you, perhaps? Like to share with us?
I'm not sure there's a specific thing, Mustafa, but let me just offer a couple of thoughts, and maybe we can put them together in some form. I think law is a humanity. I think law is not ultimately a science, as some of us like to say. Law is something that should help us understand and relate to each other. And because that's the way I view law, because that's what I think ultimately law is, I think we need to broaden our perspective and study law, not just in terms of doctrine or technique or process. I think we need to study law in terms of context and values. We need to understand its history. We need to understand history broadly. We need to understand philosophy. We need to understand the background to law, what makes it work, what makes it tick, because it exists in a social setting. And very often in law schools, even today, we forget about those things. And lawyers are primarily trained as technicians, individuals who can manipulate doctrine to accomplish a particular result for a client. And I think that client service is certainly something that, you know, a lawyer should pay attention to, should attend to, should involve themselves in. But the law generally is a higher calling. And I think it is our civic duty to think about the law in larger terms. And I think we need to get out from under our clients sometimes and think more proactively and more creatively and more aggressively about what law should be, how it should be improved, and how it can be made to work for everyone in, say, a challenging setting such as the one we are in right now. We don't give enough thought to those kinds of things. And in order to think about those things, I think we have to approach law very broadly in terms of the things that are relevant to it. I think we have to look outside the box of our traditional training in a variety of ways. I think it's extremely important that we do that. I don't think that law schools equip people to do that properly now. They narrow them too quickly, so they don't really have any kind of sophisticated appreciation of history or philosophy or ethics or other values. Maybe we need to speak a lot more and think a lot more about justice and wisdom and ideas like this, which are at the core of what law is and should be, I believe, but which have been largely missed in legal education, to the extent that, if you go into a law school today and wander the halls, or when you could do that, you wouldn't hear the word justice that often. You'd never hear the word wisdom. And I think because we're not hearing those words, I think that's evidence that we're to some extent missing the point. So I think we need to be more ambitious in how we look at law. I think law students need to be ambitious in the terms in which they think about law. They have to be intellectually ambitious, socially ambitious, morally ambitious. And ultimately, at the end of the day, they need to realize that, lawyers are not just, again, client agents. Lawyers are individuals who are responsible to some extent for the education of citizens. And lawyers themselves have to be good citizens. And again, to be a citizen, I think, requires that you be more than just a technician. One last thought. Law traditionally has been a highly imitative art, or at least a highly imitative practice. There is an expression that you see and hear a lot in the United States. It's percolated in other directions internationally now. The notion is that you should be trained to think like a lawyer. I don't know what that means. I don't think I want to know what that means, because it's primarily reductionist and narrowing and imitative. Yes, I think it's good to know how some lawyers think, but I don't think that lawyers should be limited to just thinking like a lawyer, whatever that is. I think that we need to be expansive. I think we need to innovate. I think we need to change. I don't think there's a necessary single prescription to the way we should be thinking. So I would just encourage anybody listening to this to take a broad view, to focus on perhaps how to make change, how to do things differently, how to innovate as opposed to simply imitate. And if you want to innovate, and if you want to change, and if you want to lead in the process of making change, you have to be broad-minded, because the successful leaders that come out of law schools in the future will not be the technicians. They will not be the people who have mastered the rule against perpetuities. They will be the ones who understand history, who understand philosophy, who understand values, who understand people, who embrace law as a humanity and see it as an agent of human change and improvement. Those are the lawyers who are going to make a difference. We hope that along the way, some of them will work with us on JURIST. But I believe those are the lawyers who are going to make a difference. And I think that's what lawyers should keep in mind as they move forward into the 21st century.
With this, we wrap the session up. Thank you so much, sir, for today and speaking to us. So many topics that were covered today. I'm sure students around the world have taken and have been able to relate a lot to this. Talking from our perspective, from the Indian perspective, there's a lot that we heard from you. What happened in the States? What happened in the UK? What happened in Canada? That a lot of that kind of resonates with what happens in India. So this conversation with you today opens up a lot of new horizons for us in understanding and interpreting how technology can be an enabling tool for us in the longer run. At Nyaya Forum as well, we hope to do the same thing as JURIST is doing. And Nyaya Forum being a platform that not only in the electronic version informs the webinars what we do, but also the blog format. We have a similar thought process just as what Jurist does, where we share legal thought, we share legal news, we try to understand how courtroom practice works and how our interpretations around the law works. So definitely, thank you so much for this very, very fruitful conversation. There's a lot that we learned today, and we hope that we can collaborate with you more in the future. And as you said, the globalization that's taken place of sorts, this conversation happening from India uh, with you in the United States is sort of a very big bridging gap that has happened, and only the pandemic has made that possible. So, yeah, we really hope that we can have such more collaboration in the future, and we can do greater things for the legal community, the global legal community, as a whole together. Thank you so much once again for everyone joining us out here, and we wish you all the best. Thank you so much.
Thank you, Mustafa. Thank you, everyone.